Okay. Thank you, everyone. As I was introduced, my name is Joseph McCarthy. Very similar to many people in the EB-5 world, I wear a variety of hats. I am an attorney. I am the legislative committee chair for a National Trade Association of EB-5 regional centers known as Invest in USA. David Kearson, who spoke earlier, is a colleague of mine on that committee, and both of us are extraordinarily active in that. And then I'm also an EB-5 regional center. I'm several, actually, and that's kind of the capacity that I'm here today to talk to you about is life as a regional center, kind of more academically, and then towards the end, I'm certain that we'll have a number of questions about kind of the reality of what it's like to be a regional center. First and foremost, what is the role of an EB-5 regional center? You've heard a bit this morning about the application process in order to receive approval from USCIS. It's one thing to get one, it's another to fly one. Once you have one, you find that you will be serving kind of multiple roles within the EB-5 community. You're obviously first and foremost a business entrepreneur. You are an overseas marketer. Often you are an amateur immigration lawyer who will, in interaction with individual investors, undoubtedly receive dozens of questions about, can I do this, can I do that, what happens if this happens, and so forth. You're an administrator. You have formal reporting requirements to the U.S. government that are obligated annually. You're a business executive, and you are also an investor representative. If your business model as an EB-5 regional center is similar to mine, in which I am not the actual hotel developer so much as I'm a financier, I have an obligation to all of the limited partners within my EB-5 regional center in order to make sure that their immigration requirements are satisfied. And in order to do that, I often have to obtain information from the enterprise itself. First, obviously, you're the entrepreneur. Many of us get involved in EB-5 because we are seeking capital for a variety of business investments, whether they're our own or if they're somebody else's. You are interested in obtaining capital. How you organize that capital can vary. Despite some of the kind of immigration requirements, EB-5 is relatively covenant-free. There are no sort of formal financial requirements in terms of how you structure your EB-5 capital. As such, you can come into a project as equity, you can come in as debt, you can come in as a hybrid. So the one of the things that EB-5 permits you to do is be fairly creative in terms of financing a project. This is sometimes beneficial to a project who has other sources of capital that are highly restrictive. Anyone that's been a junior lender to some senior knows that you're going to subordinate and they are going to provide you an intercreditor agreement that's going to be lengthy. There are no formal requirements in terms of what the cost of capital is for EB-5 money. It is inevitably what you can market a project and obtain investors to come into, but there's no preset amount. You don't have to, for instance, come in at several points above LIBOR or at 5%. There are certain myths within kind of the development community that EB-5 is free money. EB-5 is not free money. It is available. It is relatively less expensive to many other kind of conventional sources, but there is going to be an expense associated with EB-5 capital, both to the regional center and to the project itself. EB-5 money can be, EB-5 money, although it is formally required to be at risk, inevitably your investors are going to be interested in what sources of collateral are available to them. Should the worst happen, they're going to be curious as to what's their recourse. How is it they'll be able to at least receive a portion of their investment back. As Kevin mentioned, you are constrained by kind of your target economic industry sectors. Your regional center is defined by geography and industries. For example, in Los Angeles, my regional center is involved in hotels, medical offices, assisted living, restaurants. But these are categories that you have to apply for in advance and remain within unless you file an amendment to the U.S. government. And Kevin described at length what's a targeted employment area, or a TEA. This is some particular geographic area that experiences 150% of the national unemployment rate. If your project is located within a TEA, then the minimum EB-5 investment drops from $1 million to $500,000. And as Kevin described, 98% of the EB-5 market is at $500,000 level. And lastly, as an entrepreneur, you are going to be very sensitive to the fact that there are project timelines, there are capital requirement timelines, and then there's immigration timelines. Immigration is blind to and often could care less about the other two in terms of USCIS will operate at its own speed. And so your project has to be flexible enough that it can await EB-5 capital's arrival. For all of EB-5's virtues, EB-5 is slow capital. And this is something that most conventional, or most developers are accustomed to, because conventional capital sources, if Bank of America agrees to lend you money, that money is going to arrive certainly within a period of 30 days or less. EB-5 is less certain in terms of whether you will successfully raise the capital, and moreover, it can often take six to 8 months for it to reach the project itself. Your other goal, you are an overseas marketer. So after you've successfully applied for and received your regional center designation, you have successfully prepared a project for which you want EB-5 investment. Now it is up to you to go out overseas and raise investment. And this often involves a lot of one-on-one, if not group interaction with individual investors to not only kind of educate them about EB-5 and how it works, but also your project and why your project is more compelling than perhaps many other projects. It is an exercise in relationship building. You are going to be meeting and speaking with these investors at length because, again, you're not just dealing with a traditional investment, you're also dealing with somebody's immigration status. These are people that often have children that they want to attend school in the United States. And so to get involved in your EB-5 project is not strictly a financial decision, it's a family decision. And if for whatever reason that your EB-5 project is risky or unsuccessful, not only is their capital at stake, but their immigration status is at stake. An unsuccessful project that fails in the early stages could lead to removal of immigrants and requiring them to return to their home country. Overseas marketing often necessitates you attending exhibits, hosting seminars, interacting with EB-5 investors. If you don't have a Skype account, get one. We're using it quite a bit. And travel. They, unfortunately, upon receipt of an EB-5 regional center, investors are not going to flock to you. You are going to have to travel to them. And all of this needs to be kind of considered also through some securities lens. You are offering a security when you are permitting them to accept a limited partnership into your regional center project. A limited partnership interest is by law a security. As David described earlier, frequently EB-5 EB-5 regional centers don't go through formal registration processes. It's expensive, it's lengthy, it's overkill. But so you rely on certain legal exemptions. Reg S and Reg D are the most popular. But Reg S and Reg D have certain requirements, and some of which relate to whether this is a private offering or a public offering. When considering your marketing strategy, you need to be aware of whether you are kind of exceeding that threshold from private to public. If you begin to post things on YouTube, a video about your project, it is quite likely you are now engaging in a public offering. And normally that would require you to register with the SEC. So all of your marketing activities need to be measured. They need to be careful. EB-5 promoting has become a boutique industry in and of itself. If you engage in some of these professional marketers, just be mindful that you are legally obligated for the message that they're delivering to investors. If there's any sort of misrepresentation or brokering without a license, you as the issuer do have legal liability that you need to be aware of. Regional center role, amateur immigration lawyer. Avoid it to the extent that you are most able. You are undoubtedly going to receive dozens of questions about a variety of scenarios in terms of immigration, their family members who qualify, what activities, how their investment is structured, source of funds. I do encourage people to engage professional assistance in this regard. And I would also caution people to be careful. You will find that as a regional center, you will use an immigration attorney as a significant resource to you. When you can, I would defer those kinds of questions to an immigration lawyer. When you're selecting one, I would inquire as to their receptiveness and availability to answer your kind of potential investor questions. And certainly, again, going back to my point of this is not just strictly an investment, this is immigration. These are real people with real family issues that they need solid advice. You don't want to find yourself in a situation where your investor has already made their capital contribution, you have accepted them as a member of your limited partnership, only to discover that there is some sort of immigration hiccup that would somehow disqualify them for their EB-5 investment. That becomes quickly a sticky scenario, and it's heartbreaking when you have to return investment like that. So, prepare in advance the best that you are able. Stay informed. Almost monthly, there are developments within the EB-5 world. As Kevin alluded to, and as David spoke this morning, EB-5 law is intricate. The regulations are often vague. And so as such, they're subject to a lot of interpretation. And the interpretation comes from the Federal Immigration Agency, USCIS. We've seen a lot of development over the past couple of years on their interpretation of certain economic requirements, legal requirements. So to the best of your ability, follow USCIS stakeholder meetings. They have one quarterly. Sometimes they're either in person. They are almost always available via conference call. You are able to file formal questions with them in the hopes that they will answer it during these calls. Develop a professional network. There are a lot of EB-5 regional centers out there these days, and a lot of the competent ones will successffully interact on a professional basis for the kind of the collective good of the EB-5 program in general. Again, as I mentioned at the beginning, both David and I are members of IIUSA, which is a national trade association of EB-5 regional centers. We have organized for the purpose of kind of developing a minimum standard of conduct, but also for informational resources and to approach the federal government with a larger, more unified voice. this is a strong resource for EB-5 regional centers and for EB-5 professionals. And then again, there are also seminars, such as today. I know Kevin speaks a great deal, David speaks a great deal. We all speak a great deal about kind of what is EB-5 and how does it work and what is required. Another hat that you'll wear as an EB-5 regional center is that of administrator. There is a lot of paperwork associated with EB-5. Recall that each investor contributes about $500,000. If you are looking at a project that's a $10 million project, that means that you are dealing with 20 investors. You're dealing with 20 visa petitions. You are dealing with 20 limited partnership agreements. That you are going to be responsible for organizing and maintaining all this information, not only for your own internal legal purposes, but once annually, it's now required that we report to USCIS. Investor due diligence. As Kevin alluded to, one of the more scrutinized elements of an I-526 visa application is the source of funds analysis. There is considerable concern on the federal government that EB-5 may become a vehicle for money laundering, for criminal enterprise. And so one of the more crucial documents is going to be your source of funds analysis. And this is a series of tax and financial records that is organized by some sort of narrative cover letter or document that shows where the money originates from and how was it transferred to the United States, which is another kind of interesting nuance. Many countries have currency constraints that citizens are only able to transfer a maximum amount of capital out of their home country once a year. For example, China, which is the most popular EB-5 investment country, there is a currency constraint of $50,000 a year. So showing how $500,000 or $540,000 by the time you add any sort of administrative or subscription fees comes from Beijing to your bank account in Los Angeles becomes a challenge. And that's something that you need to be prepared to address within your kind of individual visa petitions. And then also job creation evidence. As David discussed this morning, the initial EB-5 visa is a provisional one. There is essentially a 2-year probationary period where at the outset you have provided them a business plan and economic study that states, these are the jobs I am going to create. Well, 2 years later, there's a look-back requirement to show, did you indeed create those jobs? And what kind of evidence are you going to use to support that? Whether it's financial records, whether it's tax records such as W-2s and I-9s. There is also, if you're dealing with employees of that commercial enterprise, you have to verify their immigration status, that they are legally permitted to be employed in the United States. So again, this is the information that just simply because you've received the EB-5 capital, from that moment you are already looking 2 years ahead to how am I going to assure that my investors have the provisional status of their green card lifted. And that's a big deal. Your reputation within the EB-5 market is very important. If you become known as a regional center who has a series of I-829s, which is the form that you file 2 years later, if you have a series of those denied, word is certainly going to spread, and people are going to be less confident in investing through your EB-5 regional center. Business executive. Although there are sort of formal participation requirements of an EB-5 investor, they are commonly limited partners, and limited partners have relatively passive roles. For legal reasons, they cannot be completely passive, but you are going to be obligated as a regional center either to kind of follow the day-to-day management of the business that receives the EB-5 capital, or if you are an entity that loans that EB-5 money to an outside business, you're going to have certain monitoring requirements, or at least monitoring duties on behalf of your EB-5 investors. You have formal fiduciary duties as a general partner to your limited partners. And so often you are going to provide some sort of annual or semi-annual reporting requirements to the limited partners and the EB-5 partnership. If in your limited partnership agreement you have offered them some sort of return on their financial investment, you're obligated to provide those returns, again, either quarterly, annually, semi-annually, but you do need to make distributions to your limited partners, and you do need to provide the necessary tax records. Investor representative. EB-5 investors are not, as I mentioned, entirely passive. They are endowed with certain rights as a limited partner. Oftentimes, the EB-5 Regional Center assumes the identity of the general partner within your EB-5 partnership. As such, you are kind of their representative on behalf of the partnership to the commercial enterprise itself in terms of getting all the necessary information to make sure that they satisfy their immigration requirements. So if you are a regional center who obtains $20 million on behalf of your EB-5 investors, you loan that $20 million to a hotel, you want to make certain that you spell out your rights to the hotel as kind of a lender in terms of if I need information regarding your employment, that you will provide it to me expediently. Be mindful that many commercial enterprises that receive EB-5 capital are typically ignorant of what are the requirements of EB-5. To them, it's just a capital source. Many industries these days are relatively starved for capital and might be willing to say or do anything simply to receive the money and be not mindful of the immigration status of your individual EB-5 investors. As such, you need to be their representative in terms of making sure that you get all of the information that you need in order to make sure that their visa process continues smoothly. A little bit about EB-5 ethics. There are currently no standardized rules of conduct. There are guiding influences. One of the most persuasive is market reputation. If you develop a reputation as an EB-5 regional center of unscrupulous practices or risky behavior, word will travel fast, and you will find that you are going to be relatively unsuccessful in obtaining EB-5 capital in the future. Worst of all, you do have a formal legal relationship as a general partner to your limited partnerships that we have seen EB-5 limited partners sue the general partner. So be mindful of the fact that you have formal obligations to your EB-5 investors, that they have legal recourse in the event that you step outside of certain conduct. Another kind of self-policing is other regional centers. Again, you've heard me mention IIUSA. IIUSA is very aware of the fact that we are not a permanent program as an EB-5 regional center. We will be up for renewal or permanency at the end of 2012. At the end of the day, EB-5 is still an immigration program, and immigration can be very politically sensitive. All it needs is a few bad actors in the EB-5 world to really draw some bad attention to the program itself, which may have a chilling effect on political support. So organizations such as IIUSA do try and promote a certain standard level of conduct. Another guiding influence is government agencies. A limited partnership, as I mentioned, is a security, and therefore you could be subject to the jurisdiction of the SEC. In addition to kind of individual investor kind of derivative lawsuits, the SEC might step in to sanction unscrupulous behavior. USCIS, in some kind of proposed legislation, is looking to kind of develop some teeth of its own in order to be able to sanction regional centers. Your regional center designation can be suspended or ended altogether. I think that they're interested in finding some intermediate measures in terms of being able to fine you. There's nothing to that extent in law currently, but it is possible on the horizon that USCIS does want to kind of sanction certain kinds of behavior within the EB-5. Consequences of bad actors. Distrust from overseas investors. Bad actors could also lead to increased regulation. There could be negative attention by USCIS to the program in general, unwanted attention by the SEC, and then erosion of political support. We're currently amidst an economic period where a program like EB-5 gets bipartisan support, but really all it takes is a few tragic stories of a family being swindled and deported that again could steer away political support from a program such as EB-5. And then bear in mind, the creation and operation of EB-5 Regional Center is a pretty sizable investment of time and money that is something that could be forfeited by bad behavior. EB-5 time frame. Probably, from a business perspective, the biggest attraction from EB-5. As I mentioned, it's slow-moving capital. After you have successfully prepared your EB-5 project to receive investment, which entails business plans, economic studies, private placement memorandums, it's a series of documents, that can take you a couple of months to accomplish, at which point you are now ready to go out and solicit EB-5 capital. Depending on the project, that could take months, if not years itself. And then once you are successfully kind of subscribed an investor, as David was mentioning, there's frequently an escrow process. This is not a legal requirement, but it's more of a market requirement that their $500,000 investment is going to remain in escrow while their visa petition is being adjudicated. The approval of their I-526 is often the condition precedent to releasing this money. And while USCIS is certainly trying to make the process more efficient and more timely, nonetheless you are dealing with usually at a minimum of a 5 to 6 month waiting time. So when all's said and done, getting EB-5 money to a project can take 9 months. And this is kind of opened kind of a new gray area of EB-5 law, which is the role of interim financing. Often projects may go out and seek some sort of bridge capital in anticipation of EB-5 capital arriving. USCIS is warming up to this idea, but there was a period of time where there was concern on the part of USCIS as to whether it was EB-5 capital that was responsible for the job creation, or was it the interim financing. Significant capital outlays. Marketing's expensive. You're going to be traveling quite a bit, which involves flights, lodging, meals, some more kind of formal marketing direct costs in terms of informational brochures or videos or hosting seminars. I often recommend to people who are considering getting an EB-5 Regional Center, don't strictly look at the cost of applying. Think about what your costs are going to be afterwards in terms of marketing as well. And then manage expectations. As I mentioned before, there's a perception that EB-5 capital is free money. It is less expensive money, but it's also slow. It is not as simple as filling out a promissory note to a bank. It does require you to spend time with investors, develop some sort of relationship with them, and inevitably get them to subscribe to your project. These are some photos overseas of kind of different marketing events. You can see that something in the way of what a seminar would look like. You have a room probably this size or perhaps even larger with prospective investors, at which time you kind of educate them on what is EB-5 and also educate them on the virtues of your project versus other EB-5 projects. One kind of professional tip, all of your marketing materials, you have to get them translated. People do not want to simply have to trust the English version. They want to be able to read it in whatever their kind of native language is. This also often applies to legal documents as well. Goals of the investor. Typically, an investor has two goals. One related to immigration, one related to financial security. A very dangerous word is often thrown around by EB-5 regional centers, and that's guarantee. They are first and foremost interested in how can you make me feel comfortable, or how can you guarantee that I'm going to get my green card? There are no real formal guarantees, but a lot of the more prudent EB-5 regional centers don't subscribe investors to the maximum total job creation that their project is going to allow. That is to say, if your project is going to create 100 jobs, that means you can get 10 investors, which potentially means you get $5 million. If your project ends up creating 99 jobs, your last investor is going to be very unhappy. So a lot of prudent regional centers may have a maximum job creation of 100, but only raise capital for 70 jobs or 7 investors. And that way, 2 years down the road, if there's any sort of fluctuation in your job creation, you've insulated your investors to a reasonable extent to make sure that they're not harmed. The more often use of the word guarantee comes in financial terms. How can you guarantee that I'm going to get my money back? The short and simple answer is you can't. And in fact, you're prohibited from offering any sort of guarantees. Within the EB-5 regulations, there is an at-risk requirement. While reasonable minds might disagree as to what's truly at risk, I can tell you that USCIS takes a very garden variety definition of it. This is not any sort of loan that 5 years down the road there's a balloon payment. If you fail to repay their funds, they have the ability to sue you. You can try and provide, to the best that you are able, some sort of financial protections, but at the end of the day, their EB-5 capital has to truly be at risk, meaning that it's subject to gains or losses, and if the business goes belly up, then they're out $500,000. Again, my recommendation is to align yourself and work with experienced professionals within the EB-5 community. You had 2 very good speakers this morning who have been involved in a great deal of EB-5 work. And really within EB-5, experience is the best teacher. You can sit down and read treatises until your heart's content, but it's having seen a number of EB-5 projects and having undergone the EB-5 process a number of times is really what separates successful regional centers from less successful regional centers. I was asked to speak about a few case studies. As I was introduced, I am an EB-5 regional center. I have regional centers in Los Angeles, Las Vegas, Portland, Oregon, and one forthcoming in Orlando. Most recently, we raised $20 million in EB-5 capital for the W Hotel in Hollywood. They needed some kind of a financial veneer to go along with kind of their primary lenders. And these days, capital is difficult to come by. As David was mentioning, there's also a forthcoming LA Marriott project in downtown Los Angeles. This is on the scale of some of your larger EB-5 projects. It's $110 million. Not the largest to date, but $110 million is a considerable EB-5 raise. And then there are also very successful regional centers in Philadelphia, and I think Florida currently holds the record for the most EB-5 regional centers in a single state, with varying success, but the same can be said about California. Again, your EB-5 projects are going to vary from group to group. There was a government accountability study back in 2005 to take a look at what kinds of projects are using EB-5 capital. At the time, I would say probably still holds the record. Hotels tend to be one of the more popular projects. And the reason is very simple. Real estate-based projects are widely more successful than intellectual property-based projects. And that is simply because most investors feel that real estate will hold its value better than an intellectual property idea, which can be very volatile. And most investors understand real estate-based projects than they might understand a solar panel patent or manufacturing. Again, you are seeking investment from an international investor who may not have the same appreciation or the same comfort level with certain projects that you might personally have. So bear in mind, if you're considering EB-5 capital, bear in mind what the market's demanding. And with that, I would like to open the room up to any questions.
Can you get EB-5 money and use a balance sheet to increase your balance sheet equity or raise money from this one based on the capital, since it is not a loan?
Using your balance sheet as collateral, or
an asset in the balance sheet?
Again, there aren't any real formal financial requirements to EB-5, so you are permitted to be as creative as immigration law will allow you and as the market will accept. If you are able to persuade an EB-5 investor that your balance sheet is kind of sufficiently secure to kind of insulate them from financial risk, then absolutely there's nothing that prohibits you from doing that.
But from the accounting perspective in the United States, you don't see that could be an issue to use that money as an asset in the balance sheet versus like a loan or debt there.
Yeah.
Another question, you mentioned it's cheap investment, cheap loan. How compared to traditional LIBOR, how cheap is comparison on that? Or?
It's whatever is negotiated with the project. Obviously, if EB-5 capital becomes too expensive, then project's likely going to decide it's not worth the headache to do. And by limited knowledge about what mezzanine capital or construction capital costs, EB-5 is significantly cheaper than those sorts of financial instruments.
Can you explain a little bit further for like the parking and parking area, 450% versus just more than national average? And besides, how often they assess that this area is below the national?
TEAs tend to be one of the more contentious topics in EB-5 law. The reason being is the regulations themselves don't really elaborate as to what constitutes a geographic area. It's a geographic area that experiences 150%, or it's a political subdivision. That's the other language of the regulation. Well, does that mean a single census tract? Does that mean the aggregation of 17 census tracts? Does that mean a county? And so often, there's quite a bit of gerrymandering that's done out there. As Kevin described, that you may have something that experiences 3% unemployment, but you are able to kind of connect it through a series of other census tracts to something that has 80% unemployment, and the average of those qualifies as 150%. With regard to the timing, what time frame that they take that average, again, that's not really specified in the regulations. what's kind of been commonly adopted by state agencies, and state agencies are the ones that are endowed with the authority to make these determinations. State agencies often use an annual average. And that helps you in the sense that it's a little, the duration of that certification will last you a healthy amount of time, a year. So, you know, I believe Kevin mentioned, and I know David also discussed, it is possible for a project to fall out of TEA. So if you're relying on a single month's worth of data to say that in June the unemployment rate of my project was 16%, well, you might want to be prepared for the fact that you know, July brings you 14.9%.
But that's my second question. So you have a problem like, you know, your first group of the people comes in, the first $10 million, and you got a $500,000 invested. And then your project is not qualified for $500,000 anymore, you have to earn money.
That's right.
Right?
So that means that your subsequent investors have to invest $1 million.
Yeah. Well, basically your project is falling apart.
That's right. Plan ahead. Put some thought into it. You know, unemployment data is fairly accessible over the internet. Follow it. See what's going on. Take a look to see if your project's at risk of falling out of TPA, you know, on the horizon. So, and again, I wouldn't recommend placing a project that is right on the nose, you know, 150%. Give yourself a little bit of a buffer.
You say that the unemployment rate has to be like 150% higher.
Yes.
Well, that's a lot.
It is a lot. And particularly in the current unemployment nationally. Unemployment nationally is 9.3%. That means that you've got to find areas that,
15%.
that's right. And this is some of the frustration of the EB-5 community and why it begins to become such a contentious subject is that an area that has 14.5%, which was, you know, astronomical by comparison to 1990 when the program was created. Are you telling me that that's not a worthwhile endeavor to invest in an area that has 14.5% unemployment? But the regulations are the regulations. David alluded to that, you know, he and I both work on new EB-5 law, and this is a topic that we are trying to provide some certainty to, some pragmatism, and some additional guidance.
I would like to interrupt right now because we're running a little over, and Joe is acting as a Q&A person right now, but we have another gentleman here that's named Brian Terwilliger that agreed to talk about what his company does that I think you should know about. It's an escrow service. And I'd like Brian to come up for maybe 5 minutes and tell you what he does, and then we can bring the panelists back up and have the Q&A formally after that. So,
Yeah, fine.